formalities.
As the court pleases, my lord.
Very well, let me place it on record that following the recusal of the assessors who had been appointed to try the accused persons in this matter, the two assessors stepped down on Friday following objections by the first accused person and did so in terms of section 6.4 of the High Court Act. I just place on record that notwithstanding my opinion that any objection to the assessor must be done at the outset, we agreed that the right could be exercised because no evidence had been laid. So we really did not set down any precedent. But the assessors have now been replaced by Ms. Margaret Chitsiga and Mr. T. Kuwanda. Those are now the new assessors to preside with me at this trial. Ms. M. Chitsiga has presided over many matters. She has already taken the oath. And there will be no need for us to administer the oath again in practice unless the accused persons insist that it is necessary in this matter. The practice is that once an assessor has taken the oath of office, he or she does not have to take it at every sitting. But Mr. T. Kwanda is recent on the register, and so he will have to take the oath of the assessor. So I will therefore require Mr. T. Kwanda to stand up. Registrar, can you give us the oath?
May you state your full name to the court, please?
My name is Temba Kwanda.
Temba Kwanda, may you raise your right hand to take the oath?
Yes, proceed.
I, Temba Kwanda, swear by Almighty God, do solemnly affirm that I will give a true verdict according to the evidence upon issues to be tried.
Yes, so help me God.
So help me God.
Thank you. Very well, thank you. You can now proceed, Mr. McKay.
Thank you, my lord. My lord, the record will reflect that this matter is coming for continuation of trial. However, my lord, there are recent developments, and I'm moving the court to postpone this matter in terms of section 165 of the Criminal Procedure and Evidence Act. The basis of the application, my lord, is that the second accused, Mike Chimombe, he has fallen ill and is not in a state that he could stand trial. My lord, I received a document dated the 22nd of February 2025 in which a medical practitioner attended to the second accused.
What is the name of the medical practitioner?
Mr. Dr. D. Ngwaru. I will attend to the uploading of the medical document on the platform, my lord, as I received it this morning when we were just about to commence the trial. The document indicates that the accused is expected to recuperate within 7 days. So my application is that the matter be postponed to Monday next week, which would be the 3rd of March for commencement of trial.
Monday, the 3rd of?
The 3rd of March. My lord, I however have another prayer that I'm praying for. I did liaise with prisons, and I'd been told that certain procedures were being done, that the accused then be brought before a government medical practitioner. And from my discussions with them, indications had been that it would really assist prisons if a directive or a court order is then issued by this honorable court that the accused be medically examined by a government doctor. To them, they underscored the fact that that would really assist them in order to expeditiously bring the accused before a medical doctor appointed by the government. So I so pray that that order then be issued, or that directive be issued by this honorable court. My lord, those will be my submissions.
Thank you. Mr. State.
My lord, the medical report in respect of the second accused person has been brought to the attention of the state, where it was indicated that he is not feeling well, and he is not in attendance in court. The state is not opposed to the application. And furthermore, it is not opposed to the proposed date for the trial, namely the 3rd of March 2025. 7 days would have lapsed, which was indicated by the doctor, within which the second accused person would have recuperated. It is the state has no evidence to suggest that the reason for the request for the postponement is unreasonable. Therefore, it is acceding to the request for the postponement of the fact. Because there are witnesses who are in attendance who have been religiously attending. Eventually, the state wishes the witnesses to be warned for Monday.
Okay. Are they? Do you think you are likely to have any problems if you take down their phone numbers and communicate with them?
It would have been much easier if they may be warned. They are seated in the car. If you may come forward.
So you want them all on Monday?
Should be sent to which we
5 witnesses.
Maybe I can have Dr. Macron excused. I can phone him. The other folk can come and do it before.
Mindulwa and Precious Isa. No, that one's not here. Bevan. Okay, I'll just repeat the names. We have Fungai, Bambi, Alban. Huh? What is this? Sorry. We have Titus Bambi, Fungai Kafunde, Alban, and Bevan. Yes, the Dr. Did you say Dr. Makoni? The Remigius Makoni. Yes. So, yes. Dr. Makoni, you can stand down. The State Council will be in contact with you by way of telephone when you require opening. As you can see, the second accused person is not in court. We have some report from a doctor that he was taken ill yesterday or was during the weekend, and we are going to personal doctor. But as courts, we work with reports by government medical officers. So we will require him to be examined by a government medical officer, who will then make recommendations to the court regarding the way forward. But the indications are that of the trial. So we will require you again on Monday. There won't be any other, you won't receive another document. This warning is enough. I must apologize, but our law is that court business takes precedence over any other business. So unfortunately, we are unable to excuse you. You'll be required to attend until you give evidence. So please come back on Monday to be here for 10 o'clock. Thank you. There's another request. States that I should order that the second accused person be examined by a government medical officer.
My Lord, I think the application is that my learned colleague has made, it is not in terms of any law that there be an order for him to be examined. It's unlike a mental health, in terms of mental health aid. He has indicated that he is not well. There's a letter by a doctor that within 7 days he would have recovered, and no one is challenging that medical report. And we expect him to be here on Monday. So there's no need for him to be examined. The court does not hasn't requested that he be examined by a government doctor. The court hasn't said that the presented evidence is insufficient.
Okay, so you're saying he's expected to recuperate within the 7 days and be available.
There's no need for him to be examined. Okay. The matter has been remanded, and that should suffice. Unless he wants the examination for some other reasons. but not for the purposes of this court.
Very well. Mr. Mugia?
My Lord, it's quite unfortunate that's the stance that the state is taking. I had advised my colleague of the need that further tests ought to be done on the accused person. In fact, the document that I'm holding, which I showed to the state, clearly elaborates certain procedures that needs to be done on the accused. So there's need for that court order, in that if the accused is then brought to a government medical doctor, the government medical doctor will then usually liaise with his personal physician, and in that liaison they usually then tell each other as to the various procedures that needs to be done on the accused.
Yeah, the issue is that your client is under prison custody, and anything to do with his welfare, health matters, is in terms of the Prisons Act.
Yes.
Yes. So the prisons, as a department, know how to deal with all these situations. There are prison doctors, to the best of my knowledge, but all I can say is that prisons have got a mechanism of dealing with such issues. The court will only get involved at the request if there's need for that. But as it is, we cannot really get involved in issues relating to a prisoner who is under prison custody. Because there's no consensus, I will not issue an order. I can only issue an order with proper application, which is properly backed by a legal framework. Very well. So you come back